Hello from Brussels to the conference of the French data protection officers. I'm very happy to be invited to say some words, especially on the role of data protection officers in the new framework on data protection, as well as on the EU-US Privacy Shield. First of all, my name is Philipp Albrecht. I'm a member of the European Parliament and of the Civil Liberties, Justice and Home Affairs Committee, which is competent for the issue of data protection standards and rules in Europe. And we have passed in the spring of this year, or of 2016 actually, the General Data Protection Regulation, and it is a real milestone in strengthening data protection as a fundamental right in the European Union and worldwide, but also it is a huge step forward to better harmonize the European market and to create a real digital single market in Europe. And we had the good outcome that with this general data protection regulation, the role and the position of data protection officers in controllers, in companies and businesses has been strengthened, and also we have now the duty for certain companies to also appoint data protection officers if they process huge amounts of personal data, huge amounts of sensitive personal data, or if they, for example, profile people in a way that they follow their behavior and so on and so on. There are certain situations, but in general this situation, the position of the data protection officer is strengthened, and that is a huge step forward. And I would say that for the exercise of the new framework and for the accountability to the new framework, data protection officers are playing a very key role and will play a key role also to interpret and apply these new rules and explain it to the board members, to those who are taking the decisions in businesses, for example, where now data protection really has to play an important role and has to be respected even more, as we have a directly enforceable EU framework which also foresees strong sanctions, meaning that if there is a breach to data protection standards in the future, there will be sanctions up to 4% of the yearly worldwide turnout of the respective company or enterprise. And that means that nobody will be able to ignore that anymore, that there is a real heavy interest to follow these rules, that there's a heavy interest also by the consumers to get trust in the application of these rules. Otherwise, they will perhaps not take part anymore in the certain offers or services or products which are brought to them. With regard to the EU-US Privacy Shield, of course, the debate is a bit abroad from the General Data Protection Regulation, because it is built on the current legal framework on data protection and will be built on the General Data Protection Regulation in the future. But the Privacy Shield is foreseeing an adequacy decision towards a third country, in this case the United States, when personal data is being transferred to this country, to companies there, or by companies here in Europe. And the new framework follows an old framework called Safe Harbor, which has been invalidated by the European Court of Justice in the case of Max Schrems, who has sued Facebook for not complying with his fundamental rights. And the court was agreeing with this and saying clearly that the safeguards which are enshrined in the Safe Harbor framework are not sufficiently safeguarding the rights of individuals. And now with the Privacy Shield there should be more protection. Sorry. The European Commission has negotiated this new arrangement and thinks that it is providing for far more protection, but there are still huge question marks in this framework. One is that the accessibility for individuals to these rights in the course of the Privacy Shield framework is very hard. It's hard to imagine that individuals really can get their rights enforced in this framework, because it's requiring that you go to arbitration panels in the United States, where you have to have a lawyer in the United States, and it's very unlikely that many people will go this way. Certainly because in some of the provisions it is a bit too vague, and also quite inconcrete what the definitions will look like of certain key safeguards in this text. And certainly because of the national security issue, which is still in the air, and what was initially the reason why the court has dismissed safe harbor, because obviously there is a mass collection of personal data by Europeans through the intelligence services in the United States, especially the National Security Agency, and their EU citizens are treated not the same like US citizens. They are far more covered by collection of data. They are far more often in this collection, and they don't have specific rights to get redress against these decisions in the United States. The Privacy Shield now tries to fix this by having an ombudswoman taking care about the complaints from Europe. But this is absolutely not the same like judicial redress, which is independent and which has been required by the Court of Justice. So many say that, many people say that this is not a sufficient safeguard either. So if you do processing only on the basis of the Privacy Shield, you might risk in the future to be again without a certain legal base for that. So I would recommend that in any case the other ways to safeguard data protection rights, for example appropriate safeguards which are incorporated as organizational and technical measures in the company's data transfers when doing transfers to the United States, are to be sought, where you can make sure that no matter what happens in the United States, certain safeguards are adhered when personal data of Europeans are transferred to the United States. I hope that in the near future we will get more legal certainty on this. I think that with the huge and important step towards the application of the new data protection regulation in Europe, which applies from May 2018 onwards, we will also have to renew the Privacy Shield. I think that the Commission should then start renegotiations again with the United States, fixing these open points on the basis of the new framework, because our legal framework has changed then, and the new General Data Protection Regulation foresees also new rights which aren't in this agreement or this arrangement today. With these words, I'd like to say that, of course, it will be key to prepare to the application of the General Data Protection Regulation. It is a new world for data protection. Until now, we are all working with national laws. The French data protection law applies based on the Data Protection Directive from 1995. In 2018, we will see that this all will be overruled by EU law, by an EU regulation which is directly applicable and which can't be interpreted anymore in all the points where the regulation says something in the way that it has to be adjusted in national law. It can only be interpreted in the course of the regulation itself by EU court, by the EU court or by national courts also. It has to be interpreted by national courts. And we will all have to prepare for this new legal framework where, of course, certain definitions, certain provisions might be different than in our today's national data protection laws. And it is important to do that early, because from the 25th of May 2018, this will for sure apply. There's no delay, there's no transition anymore, there's no interpretation or implementation needed anymore. It will apply directly and it will overrule everything else. So therefore I would like to advertise for getting into the substance right today and from now on intensively, and try to get also everybody aware that you have to be compliant with this new framework from May 2018. I hope that this will be also an interesting exercise and altogether also a successful exercise for all of us to get a harmonized legal environment and therefore a single digital market in Europe. I hope that you will help doing this, not only for us, the EU legislators who would like to see these laws being on the road as soon as possible, but also for everybody else who is perhaps not prepared right now and needs your advice. So thank you very much for your work. I hope you will have a good conference and I hope that we see each other at the next occasion. Thank you and best greetings from Brussels again.